In all states and territories of Australia, there is legislation regulating the leasing of retail shops. In Queensland, that legislation is known as the Retail Shop Leases Act. Failure to comply with that legislation can lead to negative outcomes, particularly for landlords. So keep watching while I tell you a bit more about it. I'm John Gallagher from Argon Law, and I'd like to tell you about some of the disclosure requirements under the Retail Shop Leases Act and how they affect landlords and tenants. Both landlords and tenants must provide written disclosure statements to each other in a form prescribed by the Act. Those disclosure statements must be signed and provided to the other party before the lease is signed. In the case of the landlord's disclosure, it must be given at least 7 days before the lease is entered into. The landlord's disclosure statement needs to contain certain information, including details of the leased premises and a breakdown and estimate of the outgoings payable by the tenant. If the landlord fails to comply with those requirements, then it can find itself liable to pay the tenant compensation and even find that the tenant is able to terminate the lease. It's therefore highly recommended that landlords and tenants seek legal advice about the form of both their disclosure statements and the lease before they sign anything. So to summarise, landlords of retail shop leases should make sure they give complete disclosure statements in the proper form, give the signed disclosure statement to the tenant at least 7 days before the lease is entered into, and if they have any doubts about the process, seek legal advice from an experienced practitioner. If you have any queries about this or any other aspect of commercial or retail leasing, I would happily answer them. And if you found this video useful, then go ahead and subscribe to our YouTube channel and have a look at our website.